having the opportunity to cause the defendants to appear on this proceeding.
I understand. I'm overruling your objections. It's fine. All right, so then the evidentiary portion of the case is closed, and I'm prepared to receive closing argument. Hold on, I'm getting up my chest clock. I'm not going to have this go on forever.
I can probably email these documents to you as soon as, well, even during her closing argument, probably.
In each 15 minutes, which is more than enough, because I don't want to hear re-arguing the other stuff. I already heard everything else from way back, and I issued a written ruling, which I presume Mr. Rose shouldn't have too much objection to. So I don't need to have all that re-argued, folks. This really just goes to the issue of punitive damages. Mr. Rose, you get to go first. You're on the clock. Go for it.
So in paragraph 17 of your decision following court trial, you found by clear and convincing evidence that defendants willfully and maliciously inflicting willful and malicious injury upon the plaintiffs when defendants purposefully and fraudulently withheld plaintiffs' funds in bad faith. So that's the basis for there being damage. Then you take the jury instructions for punitive damages, punitive damages. The jury, at least, is instructed to consider whether the defendant disregarded health and safety of others, whether the plaintiffs were financially weak or vulnerable, whether their conduct involved a pattern or practice, whether the defendant acted with trickery or deceit, and then the jury instruction goes on to talk about how there should be a reasonable relationship between the amount of punitive damages and the potential harm likely to occur because of its conduct.
What's the CAFI number? What's the CAFI number? So I can...
The CAFI number is
3942. 3942, Your Honor.
Thank you. Okay, go ahead, Mr. Rose.
So the punitive damages should be sufficient to deter, in light of the defendant's financial condition, to deter them from future wrongful conduct. In this case, the fraudulent conduct that, well, I'm not going to get into all of it, but there were the three most egregious fraudulent things that the defendants did to try to steal these plaintiff's security deposit was they attached a forged lease to their cross complaint. Mr. Torres falsely testified in his deposition that he spent 300 hours replacing the tile deck when it turned out that the time he had spent was way less than, not even a third of that, and that he had not replaced that deck. And most egregiously, the entire whole series of deceptions and fake documents around trying to establish that they had spent $5,000 to replace rather than simply a few $100s to repair this granite countertop. So, how much punitive damages are appropriate given that behavior, and given that these defendants they're not extremely wealthy, but Mr. Torres at least makes a good living, probably on the ballpark order of $10,000 a month, and they own other rental properties. Their behavior was reprehensible, involved a pattern of trickery and deceit, especially the behavior around in the fake documents presented around the granite countertop. They told 2 or 3 different stories about what happened with the granite countertop, and we never did get the true story. They ended up saying that, or they ended up blaming their contractor, claiming that he had somehow deceived them. I think that I don't know, if I had a jury, I think I would be arguing for the $10,000 in punitive damages against each defendant should be sufficient to deter this conduct. Especially in light of the fact that the court has already awarded the plaintiffs approximately $29,000 and some, approximately $30,000 in compensatory damages. So the punitive damages should, I guess there's some rule, it's supposed to be some multiple of that. But I would suggest it doesn't even have to be one time that. I think that $10,000 punitive damages each is sufficient on top of the already almost $30,000 compensatory award that the court has already issued.
Thank you, Mr. Rose. Ms. Turnage?
Yes, Your Honor, thank you. And since he's brought it up, I just want to bring this up as well. Apparently the court did not believe my clients when they said that they were duped, and I will assure you that when the installer testified that he had not told them about this, they thought that the granite had been replaced completely, and it was only during this trial that this happened, that they learned that it was pieced in, because some granite installer crew who was not being supervised dropped the granite and broke it. Moving on, the plaintiff has the burden of proof in a punitive damages case, and before I get into that, I just want to mention that Mr. Rose's statement that there's a pattern of deceit in this case, the court cannot consider any pattern of deceit alleged. Where it becomes relevant is if there's a pattern of deceit by my clients with others other than the parties in this lawsuit, and there's been absolutely no evidence to show and to persuade the court and that is admissible to suggest that they have defrauded other people in other tenancies, and so therefore that doesn't go anywhere in this case. The whole purpose of the statute that gives punitive damages is to deter conduct in the future, and it becomes very important that the court is given accurate, admissible evidence of their financial wealth now, not back in 2009, not back in 2011, and if the plaintiff fails to do that, which these plaintiffs have done, then the court cannot consider that documentation now supports their current wealth. There are a lot of things have happened in this world. There's been COVID, there's been lockdowns, there's been people not working. My clients are no different. I will tell you that Mr. Torrey's employment has changed even before COVID, and he no longer works for the employers that the witnesses testified were the fact back in 2015. So to accept anything about what they think they might be doing today and what businesses they have and what is current now would be pure speculation. There is no evidence before this court that establishes their current wealth condition, other than we've given them the tax returns for 2018, and you'll have those in 2017. But again, we're 3 years later, and things change, and things have changed in their lives. They've had an ill child, they've had to take care of and pay for outside of insurance coverage with an autoimmune affliction, and they've been paying out of pocket, and that's been a real hardship for them in the last 6 months.
Ms. Turnage, just a moment.
Yeah.
Can I just say, there's no evidence, I have no evidence of that. Your clients didn't show up today to give testimony. You're testifying. I have no evidence in the record of the calamities they've suffered over the last few years. So, if your clients have decided not to come, there's a consequence to that. They don't get to present the evidence that they'd like to present that make them appear less able to pay. So please limit yourself to the evidence that was actually presented here today.
Okay, all right.
She's never testified. I didn't cross-examine her as to those contentions.
This is
claiming
closing.
Mr. Rose, I've already cut her off even without objection. I already cut her off.
Yeah,
Let's let her move
Yes,
on.
that floor, I'd like to cross-examine her.
This is closing argument.
Moving on.
Okay. Okay, so moving on. There's also in the Cassie instructions with 3942 Cassie, it talks about the importance of the court understanding not only the assets but the liabilities of the defendants. There is no evidence before you of their liabilities. And you've already said, we've not put anything in, but they didn't either. And so to be able to come to a conclusion as to what their wealth is currently in assets against what their liabilities are, the court is hamstrung on that. You don't have the evidence, and therefore the punitive damages cannot be awarded based on the evidence for the reasons that I've stated. And we would ask that you not award any punitive damages based on the lack of evidence offered by the plaintiffs, and that they have not met their burden to prove to you that the financial condition currently is such that you can calculate that and determine what amount would be proper to punish them. And in fact, the instructions to Cassie 3942 allows a jury, and of course the court, to even determine not to order punitive damages. It is all based on the proof at trial. And so we would ask that you not award punitive damages. Should you decide that some punitive damages should be awarded, and I don't know if this is proper, but my clients have requested that I would ask the court to work through a payment plan. And I don't know if the court can do that, but I am mentioning that. Again, we don't, the evidence has shown a lack of preparation and a lack of calculations as to what would be proper. I'm not sure why Mr. Rose thinks that they should even be awarded $10,000 for each plaintiff. There's no calculations to determine that, and so we would ask that the court deny the punitive damages be awarded in this case. Thank you very much.
Thank you, Mr. Reply, Mr. Rhodes?
Yeah, Ms. Turner wanted to put on evidence of Mr. Torrey's changed employment, or gets a child, or liabilities, and she could have done that, and she didn't. So she's stuck with what the court can infer from the past. Fact is that Mr. Torrey's for years and years had a very good job where he earned approximately $10,000 a month. And these people they own multiple rental properties. For years and years, they've owned multiple rental properties. They've had several different businesses. They had, Ms. Campbell was a real estate agent. She had a nail salon. She's an entrepreneur, and there's no reason to think that she hasn't continued in similar vein. And probably she has been affected by the coronavirus and the pandemic and the shutdown. But if they wanted, but that's not going to go on forever. That's a temporary circumstance, we're hoping. And if they wanted to present evidence of that, they could have done that, and instead of deceiving me, claiming that she's going to be here and then having her not show up. So I think $10,000 each is an appropriately moderate amount of punitive damages, particularly given the level of deception that particularly Mr. Torrey carried through these lies and came this. The court frequently, I think, during his testimony, I think the court had admonished him for dissembling, which to me means that the court thought he was lying, and he was. So that should be discouraged.
Okay.
All right. Thank you, Mr. Rose.
I did fail to mention one thing, although counsel did in his closing argument. Your Honor, you already awarded the bad faith damages under 1950.5 under the conversion cause of action. And I believe you've already spoken about that they've already been awarded some punitive damages under the statute. So I would ask that, if you do decide to award something, that it be very small, because they've already they already have been awarded punitive damages from your decision following court trial.
Understood.
Thank you.
Okay, folks. Thank you, folks. All right, so I'm prepared to take the matter under submission. I obviously will, I'm gonna wait a couple of days before I look at anything you emailed me, Mr. Rose, just to allow Ms. Turner the opportunity to look at the email herself, and if she has any